Good evening, ladies and gentlemen, and a very warm welcome to you all for tonight's Current Legal Problems lecture with Professor Joana Mendes. My name is Mark D'Souza. I am one of the editors of the Current Legal Problems lecture and journal. And my role tonight is largely ceremonial. It's mostly to get out of your way because you're here to listen to our fantastic speaker. What I will do is I will introduce our chair for the evening, who will then introduce our speaker. Our chair for the evening is Professor Niamh Moloney. She is Professor of Financial Markets Law at the LSE Law School and has previously served as head of the law school. She's a fellow of the British Academy and an honorary member of the Royal Irish Academy, and was awarded an honorary doctorate by the University of Zurich. Professor Moloney has written a number of books on EU financial regulation, and she sits on the editorial board of a number of journals, including the European Law Review, and she's the series editor of the Cambridge University Press series on international corporate law and financial market regulation. She's an independent director on the board of the Central Bank of Ireland and a member of the Board of Appeal of the European Supervisory Authorities. She's also a former chair of the Irish Commission on Taxation and Welfare, and is a member of the Advisory Scientific Council of Better Finance and the Advisory Academic Committee of the European Capital Markets Institute. That's quite a lot to get through. We're absolutely delighted to have you here moderating the event, including the Q&A session that will follow the lecture. So just a short note on the format. Professor Mendes will speak for approximately 40 minutes, and that will be followed by about 10 to 15 minutes of Q&A, which we realize is quite short. And so we invite you, and in fact strongly encourage you, to join us after the event outside in the hub, where there will be a drinks reception, and you can bend Professor Mendes' ear a bit more. So that's all I'm going to do. I'm getting out of your way now. Professor Moloney.
Mark, thank you so much. And it's really a huge privilege to be chairing a current legal problem. It is one of those defining events in the academy calendar in the UK for so many years now. And I'm really honoured, Mark, to be here. And all the more so to be chairing a wonderful scholar like Professor Joana Mendes. So Joana is Professor of Comparative Administrative Law at the University of Luxembourg, a hugely distinguished scholar, particularly in the area of administrative law. So many distinctions, but just to point out a few, she's been a Fulbright visiting scholar at Yale Law School. She's been a visitor at the University of Coimbra, the European University Institute, and the Luis Guido Carli School of Government, co-editor-in-chief at various points of the German Law Journal, the European Law Journal, and has the huge distinction of being the co-founder of European Law Open, a really significant publication for us all. Since 2020, she's been head of the doctoral school in law at the University of Luxembourg. And in all of this, she has a canon of work which has been hugely influential. Her OUP book, of course, two major edited collections, one very important one in particular, very close to my heart, on EU executive discretion and the limits of law, which is a hugely significant landmark, I would argue, in how we think about administrative law. And if I could take just a second, Joana, to really thank you for your scholarship. It's a bit of a trope to say the administrative state, the regulatory state is expanding at speed, and we all know that's the case, and of course UCL has been such a thought leader in this space. But there are very few scholars, Joana, who can interpret and explain how administrative law and public law frames, thinks and constrains how the regulatory state should operate. I'm personally deeply grateful for the depth and richness of your scholarship, which has helped so many of us in specialist areas of regulation, from financial regulation through to health, through to food, through to chemicals, think about defining concepts like proportionality, legitimacy, accountability. What does it mean to have judicial review as a legitimation device? You're one of the very, very few people who can speak both languages, and I'm enormously grateful for your scholarship. Your Common Market Law Review work, your European Law Journal work, your Modern Law Review articles are seminal contributions to how administrative law gives us new ways of seeing as regulatory lawyers. So I'm hugely looking forward to your lecture, and I will hand over to you now.
Thank you, Niamh. Thank you so much for the invitation to be here at UCL. And thank you so much for this kind introduction. I honestly don't know what to say after. It's a delight to be here, and it's a delight to be introduced by you truly. So, and let's hope that I will rise to the expectation. So what I'm going to present today is the result of an ongoing work. And the background of it is a perennial theme in public law. There is a disconnect between that exists also in EU law, not only in public law general, between what administrations do and what lawyers, what public lawyers perceive their role to be in relation to the law. So lawyers assume that where law is present, law directs administrative action, legal norms retain in every circumstance their role of defining mandates, competences, limits, goals, and decision-making structures, all of which can be ascertained by courts in judicial review through various degrees of judicial review. This positioning that I just briefly outlined is certainly not specific to EU law, as is not the unattainable subordination of the administration to the law that I'm going to be talking about today, but it is a particularly pressing problem in EU law, I would argue. And it is so because law has been a core foundation of the authority of EU law, and decades of judicial elaboration of the EU legal system have fleshed out an essential tenet of the rule of law, that law both grounds and constrains the exercise of public authority. The functional needs of integration, or simply the necessity stemming from new realities for which legal solutions must be crafted, have often constrained the ability of the law to ground and constrain. The tensions that have stemmed from this have been often at the core of sometimes quite dramatic legal disputes, such as in the Weiss judgment dispute between the Court of Justice and the German Constitutional Court. But in one way or the other, the EU courts have always found a way, or the legal services of the institutions have always found a way to ultimately uphold the enabling and constraining role of the law, even when the solution found remained contentious. Time and again, in high-profile judgments, the court recognized the challenges of making the reality fit the system, but time and again, the court has found a solution that maintained the legal fiction of subordination within the limits of its jurisdiction. So what I argue is that behind this appearance of subordination to the law lie powers that, for structural reasons, and I will talk about those later, cannot be subject to legal strictures in the way that the case law and the system of law that the courts have contributed to develop seems to uphold. Instances where administrations get to determine the meaning of the law that is binding them, instances where the courts cannot constrain those administrative powers but can only enable those administrative powers. So I want to zoom in on those instances and bracket the subordination to the law for a while to understand the role that law actually has in areas where administrative powers are deeply imbricated in society, are deeply imbricated in the economy, and also to understand the relative positioning of courts and administrations in that regard. So in the next 30 minutes, I hope, and please keep me in check, I will guide you through the intricacies of banking regulation and pesticides regulation, which is quite indigest for a Thursday evening. I hope that you will bear with me for a while until I try to make sense of all of this together. And I will also be speaking under the authority of the experts in these two fields that may be in the audience, because I am not an expert in either of these fields. So you have the outline of the lecture there, and I won't now explain. So I will start with banking regulation. I will then go into the example of pesticides that I want to bring to you as well. And in the first part on banking regulation, I will essentially argue that at least one of the conditions that delimits the power of banking resolution does not provide legal grounds that are external to the administrative action that it is supposed to constrain. So that is the main argument that I'm going to make on that part. And when I will be analyzing the aspect of pesticides, of the legal regime of pesticides that I will bring to you, I will argue in essence that in the cases that I'm analyzing, the legal norms are means of mediating the processes through which different actors define how public interests are composed, and that the courts are then much less controlling legality than mediating also these processes through which public interests are pursued in areas of deep complexity. So this is the main argument of the both parts, and in the final part, I will summarize. I will bring these threads together. So banking resolution. And I'm speaking under the authority of Niamh Moloney here. So banking resolution, the legal regime that we have today was set up in the aftermath of the financial crisis. And it is one of the pillars of the banking union. So what it in essence gave to the European Union was the possibility of determining the winding down of a credit institution or a group if three conditions of action are fulfilled. If the entity, I have there the norm that I'm going to be then speaking about. Those three conditions are those first three that you have there, and that's the most important to pay attention to. The entity is failing or likely to fail. There is no reasonable prospect that any alternative private sector measures prevent its failure in a reasonable time frame, and the resolution is necessary in the public interest. This is an exceptional power in a double sense. It is exceptional because the regulation, this is only one of the norms of the regulation. The regulation set up a whole legal regime of preventing resolution, right, and that is core. It is also exceptional because of the policy implications that a decision of this sort has, and resolution authorities will be more than happy to avoid taking this decision, to avoid getting to the point in which this decision becomes inevitable. But at the core, what I want to emphasize is that at the core of the decision of resolution, when it happens, and hence at the core of the whole regime of the banking crisis management, is the assessment of whether there is a public interest in the resolution. And that's what I want to focus on. In the EU, this decision is going to determine whether the failing bank will be subject to a national insolvency procedure in case that public interest is not present at EU level, or whether it's going to be resolved through the EU administrative procedure. So it's also a decision defining the level of government at which action is going to take place. And each option has significant impacts, different implications at the level of protection of creditors, involvement of public funds, and the transnational mutualization of risks. The stakes of finding that there is a public interest in resolution are so high that they have both mobilized and defied the strictures of the Moloney delegation doctrine. Or in other words, this is why I bring the Moloney doctrine here, the ability of the law of defining objective criteria and conditions that delimit the powers of the agency and preclude a transfer of responsibility. The procedure for determining the resolution is extremely complex. Each one of those conditions is determined by different public bodies in different combinations, so I'm not going to guide you through that. What I want to emphasize is that the assessment of whether there is a public interest in resolution is something that is made by an agency, the Single Resolution Board. And the Commission participates in the meetings of the Single Resolution Board. This is an important aspect. And crucially, a positive decision, not a negative decision, a positive decision that there is a public interest in resolution is subject to the Commission's endorsement of that decision in extremely tight timeframes because of the sensitive nature of this decision. But the Commission can object what the Commission can do is either endorse or object on the grounds that that public interest is not verified. So because of this scheme, the regulation disconnects, on the one hand, the competence to determine the resolution scheme, which is a competence of the Single Resolution Board, and the possibility to formally decide on this discretionary aspects, which is a competence of the Commission with its endorsement, right? In doing so, I argued it diffused the power of resolution through the complex administrative system because, as the court had said it and the Commission has argued before the court, it is absolutely impossible to disconnect technical aspects of this assessment from the political discretionary aspects that are involved in defining whether there is a public interest in resolution. So the power of resolution is actually diffused through this complex system that has been created. This system was tested notoriously in 2017 with the resolution of the Banco Popular in Spain. And there were hundreds of actions against the decisions of resolution. Of these, the court picked 6 pilot cases that have defined a jurisprudential line of the General Court on this matter. Of these 6, most were filed against the SRB's, the Single Resolution Board's resolution scheme. Some were filed against the SRB's decision and the Commission's endorsement, and one was filed against the Commission endorsement only, which gives you the sense of how unclear it was who was the actual author of this decision. This question of who was the author became a question of compliance with the Moloney doctrine. And the reason why this matters for my argument is what I mentioned earlier, is that compliance with the Moloney doctrine is also a question of whether there are objective criteria and conditions, and I'm quoting from the case law, that delimit the powers of the agency and preclude a transfer of responsibility. The court, in the judgment Fundación Tatiana Pérez, the Court of Justice, has considered, has considered that there were sufficiently objective criteria and conditions. It said what is there, the wide margin of discretion of the SRB in that case is, by virtue of the norm that you had previously on the slide, circumscribed by objective criteria and conditions as delimited the scope of action of the SRB. Public interest, and this matters, is legislatively defined in the regulation. Public interest, the regulation says, is considered, a resolution action is considered necessary in the public interest if it is necessary for and proportionate to the achievement of the resolution objectives, that I will tell you in a bit what they are, and if the winding up of the entity under normal insolvency procedures would not meet those resolution objectives to the same extent. Those objectives that are defined in the regulation are ensuring the continuity of critical functions, avoiding significant adverse effects to financial stability, are protecting public funds by minimizing reliance on extraordinary public financial support, protecting depositors, investors, protecting client funds and client assets. These are the objectives. So the determination of what is a public interest in this case intertwines both economic considerations, clearly, but also legal considerations, because we're talking about the protection of depositors and investors. It is clearly a technical assessment. It's obviously clearly a deeply political assessment that will determine how these competing goals are actually going to be composed, are actually going to be fulfilled. What I want to underline here is not this technical political issue, is the fact that this is a legal condition of lawful action. Okay? So that is the point that I want to underline here. It is an objective condition of action that delimits sufficiently the powers that are at stake here. This means, So when the Court of Justice considered that there are objective conditions of action that limit the powers of the Single Resolution Board, it was clearly doing that because of the political controls of the Commission, right? This is the scheme of resolution in the regulation. But what I want to underline is that according to the court and the way it has developed the Moloney doctrine, the same characterization of there being a clear objective condition of action means that it must be subject to judicial review. It must be amenable to judicial review. But the issue and the problem is that the court cannot possibly, in this case, conduct a judicial review that constrains the finding that there was a public interest in regulation, right? And I'm going to elaborate on that by talking about, by talking about the Elevate Invest Group judgment, again, one of these judgments that was involved in that stemmed out of the resolution of the Banco Popular, where the applicants tried unsuccessfully to set legal boundaries to the verification of public interest and argued before the court that that condition had not been verified. One of the things that, and they argued that there was a breach of proportionality. The court dismissed the argument very quickly. There is a legal requirement in the regulation according to which the Single Resolution Board must minimize the cost of resolution and avoid the destruction of value unless necessary to achieve the resolution objectives, okay? The court considered that this is a legal requirement, the court considered that this could not be interpreted as a limit to the finding of public interest. What the court said on this matter, rather summarily, quite quickly, was, and I'm quoting, where the destruction of value caused by the resolution tool chosen is necessary to achieve those objectives, it is in the public interest. And hence, the resolution cannot be disregarded as disproportionate. Right? Full stop. This was what the court said. It did not assess why the destruction of value was necessary. It did not assess, and when it assessed whether the SRB had minimized the destruction of value that it was legally obliged to do, the court simply reiterated what the decision of the SRB said. My point here is not to criticize the court, so that's not what I want to do, and not to criticize the degree of judicial review. The point that I want to make is that setting legal boundaries here to such an open-ended legal condition of action is outside of judicial reach. It's outside of the purview of the court. Digging out the minutiae of the case law to prove the court wrong, we may do that, obviously, or to show the possible shortcomings of the analysis of the court, must not ignore the limits of the legal norm that the court is using to adjudicate. So this is the point that I want to make. And this norm that sets out a condition of administrative action in the terms that you have seen in the first slide that I showed, the action is necessary in the public interest, meaning that it's necessary for the achievement of or proportionate to the objectives of resolution, etc., does not provide legal grounds, this is my argument, that are external to the very administrative action that it is meant to constrain. It's not external to the very administrative action. It does not provide legal grounds that a court can reinterpret and thereby shift or steer the administrative interpretation of the norm, or the administrative assessment of necessity, I should say. If it were not a legal condition of action, there would be no question about defining what is in the public interest being a competence of the administrative authority, right? It not only justifies the recognition of discretion, it is the very purpose of finding the public interest is the very purpose of the mandate and of the function of the administrative body. It is the raison d'être of the whole administrative system that has been set in place to determine what is in the public interest. What I'm saying is that the fact that the regulation turned it into a condition of action, a legal condition of action, does not transform, does not make it more amenable to judicial review. Claiming otherwise is maintaining an untenable fiction of subordination to the law and of the ability of the court to uphold it. And it means ignoring the circularity that these norms entail. And that circularity means that we will only know what they mean once the administrative action has been set in motion, right? That is the only moment in which we can determine only what is lawful and unlawful through the action of the administrative system. And so those limits, the limits of judicial review, they stem from the nature of the powers that are at stake. I had indicated that. These powers are future-oriented because they are geared towards achieving the objectives of the regulation. They reflect a high degree of complexity, of situational dependence and unpredictability that characterizes this situation. And as a result, the object of the law, which is the powers that it delineates, cannot be normatively determined. And this is the point that I'm going to continue with when I'm moving now to pesticides. Brace. Brace for what's coming next. So, in the norms, I have there on the slide, the norm that determines one of the norms, the central norm that determines the conditions under which the Commission may authorize or must actually authorize active substances that are components of pesticides. It has a similar structure to the structure of Article 18 of the Banking Resolution Regulation, just in the sense that it sets a series of conditions, and once those series of conditions are verified, the Commission must authorize, right? You have there on the slide, it's an extremely complex norm to read. But what I want to highlight is that there are 5 conditions for the authorization of pesticides. I'm going, for the sake of simplicity, I'm going to refer only to absence of harmful effects on human health and unacceptable effects in the environment, to refer collectively to all of these that have a similar, they all have a similar type of wording. What do I want to say in this regard? The absence of harmful effects or unacceptable effects on the environment are value-based predicates, right? And what I want to highlight here is that they have a triple function. I've been talking about legal conditions of action, right? They are, first of all, legal conditions of action. If demonstrated through the information that the applicant gives and the administrative assessments that follows, if demonstrated that these effects are not present, then the Commission must approve. If it's verified that these effects are present, then the Commission must reject. So it's clearly a legal condition of action. But it's more than that as well. It is also, these harmful effects or unacceptable effects are also the purpose of the legal regime. The whole legal regime has been conceived to prevent the production of these effects while improving the functioning of the internal market and agricultural production. These are the objectives that are set in the regulation. And the regulation also says that administrative action must achieve a high level of protection of both human and animal health and the environment. It's clear that establishing an order of priority between these, protection of health and the environment, internal market, and agriculture, is extremely complex. This has been pointed out in the refit evaluation of the regulation, where the Commission held that the objective of the regulation is not to eliminate pesticides, but rather to minimize their impact on human health and the environment. This precision strikes at the core of the problem, of the opposing interests that pesticides mobilize. Their importance for agriculture cannot accommodate elimination, clearly. changes to that public health and the environment would require, in particular in evolving loss of biodiversity, would be such they meet not only the opposition of farmers, but also the opposition of the chemical industry that sustains their modes of production. So whether and how the protection of human health and the environment prevails over these competing goals depends on how these objectives are going to be understood during the administrative process. That in turn is going to determine, in instances of scientific uncertainty, what harmful and unacceptable effects are. Absent these assessments that the administrative system was set up to produce, it is impossible to know the meaning of these terms. It is impossible to know what is harmful, what is unacceptable. Harmful and unacceptable have a third key function. They are the material foundation of the administrative system that enables the Commission to take these decisions. They justify the complex system that has been set up to enable the Commission to take a decision of authorization or rejection. This system includes the Commission, includes an European agency, the European Food and Safety Authority, includes a comitology committee, includes the industry on whose application depends the triggering of the whole procedure. All these actors are involved in the procedure that the pesticides regulation has designed to determine whether unacceptable effects or harmful effects may be produced. The respective role of all these actors in the procedure depends on their resources, depends on their political and administrative capacity within the EU legal system, depends on how far that capacity allows them to authoritatively ascertain what are harmful and unacceptable effects. The Commission is at the apex it's not the Commission is the author. Here there's a clear author, but the Commission is at the apex of an administrative system, but is also embedded in that administrative system. And it gets to determine the meaning of harmful and unacceptable, and hence the meaning of the norm that is binding it. When I'm saying this, I'm pointing to the fact that this is something different than interpreting a legal norm. This is also something different than exercising discretion. This conceptual framing that lawyers use does not capture the nature of the powers that is here at stake, because of the absence of external material limits to the powers of the Commission in this case. What I've argued and what I've been arguing so far is that the law does not set external material limits to the power of the Commission in this case. Because, as I've said already, it is impossible to know what unacceptable effects are before setting in motion the whole administrative system. And this means that Article 4 does not provide legal grounds to ascertain the lawfulness of the administrative decision that are external, again, same argument, are external to the very administrative action that it is meant to ground and constrain. And this obviously has an impact on judicial review, right? And this is my second point now. I'm now going to move to how the court has dealt with judicial review of under the pesticides regulation. I will make specifically this argument that this has an impact on judicial review by analyzing a recent judgment of the General Court that is currently under appeal, Pan-Europe of February 2024. The interpretation of unacceptable effects on the environment or harmful effects is hardly ever at the main object of judicial challenges on the authorization of pesticides or rejection. Pan-Europe is an NGO, a Brussels-based NGO, that challenged a Commission decision of renewal of an already approved active substance, alleging the only grounds of appeal was the infringement of the precautionary principle and of the Union's obligation to ensure a high level of protection of human health and the environment. This was the only grounds, the only legal grounds, the only plea invoked. This was one of the few cases where claims of illegality are brought against a decision that is deemed to be insufficiently protective of the environment as opposed to excessively protective of the environment. And I owe this distinction to the work of Julia Leonelli, which has been quite fundamental for me to make sense of this sector. What Pan-Europe challenged was the Commission's practice that the Commission has developed over the years of renewing the approval of substances when the agency, the EFSA, identifies critical areas of concern. So the agency scientifically establishes critical areas of concern, and the Commission nevertheless approves subject to mitigation measures being adopted by the member states after the substance has been approved. This practice has been criticized by the European Ombudsman, has been criticized by the European Parliament, always concerned about it not being sufficiently protective. But the Commission has reiterated the legality of its practice and its interpretation. And Pan-Europe tried to challenge this judicially. And to do so, it advanced a systematic interpretation of Article 4 of the Pesticides Regulation based on the precautionary principle to establish limits. To say that because the whole regulation is based on the precautionary principle, something that the regulation says, that constrains the discretion of the Commission in these cases by way of the law. So that we must interpret Article 4 in light of the precautionary principle, and because the precautionary principle gives prevalence to the protection of the environment, the Commission would be constrained. The court, this provided a line of argument that the court could have used to interpret Article 4, in whichever direction it would go, right? But the court did not do that. The court took a different route. It did not address the question of whether there would be legal grounds to constrain the power of the Commission. It simply shifted away its analysis from the interpretation of Article 4 as a substantive requirement for any decision taken in this matter to the scheme of risk assessment and risk management of each individual decision that inevitably and logically gives discretion to the Commission. So it avoided giving an interpretation on Article 4 that could constrain the argument of the Commission. And again, my point is that it could not have done otherwise or better. My argument is not that the court should have established limits. That would require a different line of argumentation. My point is that this legal condition of action does not give enough constraints that are external to the powers of the administration in this case. The limits of the law, the limits that I've been pointing to, does not mean that judicial review is going to be meaningless. There has been plenty of litigation in the area of pesticides regulation. And I will make this argument more, I will develop this more in the article, in the written version. What I argue there is that in the judicial process, Article 4 changes its role. It becomes a norm that allows the court to define the burden of proof and the standard of proof, which means that it also has an essential procedural character. The court is not defining, obviously, what is acceptable, unacceptable. My conclusion, if any critique can be brought against the court in the cases that I have examined, is not that it has failed to strike a balance in the degree of intensity of judicial review. That is not my point. It is rather that in each case, the pronouncements that it has made have perpetuated the fiction that the powers that it is reviewing are amenable to judicial review because they are subordinated to the law. When the court says that the SRB regulation has established objective and clear criteria of administrative action, when it says that the resolution tool cannot be regarded as disproportionate if it is necessary in the public interest, when it says that the norm the norms setting out, which is one aspect that I forgot to mention, that the norm setting out the legal conditions of authorization of pesticides constrains the discretion of the Commission as a risk manager. The court stated clearly that both the precautionary principle and Article 4 constrain. What I am arguing is that these powers cannot be subordinated to the law in the way that these pronouncements convey, because of the nature of the powers that are the object of the law. They are future-oriented, as I already mentioned earlier. They are group-relevant, and I will get back to this. They are highly complex, they're situationally dependent, and they display various degrees of uncertainty. These characteristics that I've just highlighted are the same characteristics of the planning and steering activities of the welfare state that in the 1970s and in the 1980s led German public lawyers to query the ability of the law to govern public powers. These characteristics, formulated like this, like I just presented them, they appear in the work of Dieter Grimm of 1990 on the crisis of the Rechtsstaat, where he analyzed the declining steering capacity of the law. So it's nothing new, what I've been arguing in a sense. The powers entailed, what I want to say is that the powers entailed in light of this analysis, the powers entailed in banking resolution and in the authorization of pesticides, they are future-oriented because they are directed at achieving the objectives of the regulations. They are dependent on prognostic and probabilistic-based assessments. They are highly complex because of the technical knowledge that they must mobilize and of the competing interests that they contend with. In particular, they depend on technical assessments that only the administrations can unravel, often in collaboration with the industry. They are situationally dependent because the determination of public interest can only be made in view of specific and concrete circumstances. They display various degrees of uncertainty. They are group relevant because they shape a political economic order. And this is the point that I would like now to focus on in the last few minutes. These are individual decisions. Resolution decisions and authorization or refusal of the authorization of pesticides, they are always formally individual decisions. They have an undisputed collective dimension, and this collective dimension is hard to capture in legal terms. It is expressed by the fact that resolution decisions determine how financial stability will exist and the trade-offs between the terms of its existence entail. Similarly, the authorization of pesticides will shape the terms in which a society is going to enjoy a high degree of protection of public health and a high degree of protection of the environment, while allowing farmers to protect their crops against pests and chemical companies to flourish, which are the objectives of the regulation. In both cases, they have an ordering function. They generate the public interests that administrative bodies are presumably bound by. These public interests are nominally indicated in the regulations, but only the situationally dependent individual decisions are going to create the conditions for these public interests to be secured. They define the terms under which various communities that are concerned by the material effects of these decisions are going to enjoy these public interests, and this makes them deeply political. Not only political, I would argue, but deeply political. So what I've been saying so far is that not only administrations get to construe the meaning of the enabling norm, and because we only know what these norms mean based on the administrative action that concretizes them, but also, and crucially, they do so, they construct the meaning of the enable norms as part of a purposive decision-making process that is set in place to give content to the public interests that they must pursue. For these reasons, I have characterized these powers as constitutive powers. public lawyers that in the 1970s and 1980s were concerned with the declining steering capacity of the law noted that the substantive weaknesses of the law could be compensated by organization and procedures that are prescribed by the law. And this is clearly the case. But the importance of procedures and organization, I mean. But what is perhaps less emphasized is that both organization and procedure are at least as much conditioned by overarching legal structures or constitutional principles such as separation of powers or limits of delegation, as they are by the socio-economic reality to which they apply. Administrations are deeply imbricated in that reality, and their powers stem from the needs that that reality generates. Because of the structural conditions in which they exercise these powers, the law that governs them is necessarily indeterminate in material terms, which means that law can only provide a porous frame of the reality that it is meant to contain. Of course, there will always be courts and judicial review, but in the circumstances that I pointed, courts can hardly weigh in on the processes through which what is necessary in the public interest, what is harmful, what is unacceptable for the protection of the environment is determined. The processes through which this is determined in the administrative system, even as these are legal conditions of lawful action. So, because, I argue, weighing in on how administrative actors have defined and understood these terms might have negative impacts on the functioning of the administrative system that the courts may prefer to avoid. It is then, if I am convincing you, it is then the administrative system that will set the parameters of what is lawful and what is unlawful, and hence the unattainable subordination of the administration to the law in these cases that I have analyzed. Thank you very much. Thank you.